Mr. Okello, good morning. Yes, Mr. Asimbiddwa.
My Lord Kumbuga Richard is my name, together with Counsel Sarah Awero for the accused person. Accused is in court. On the prosecution side, led by the Land Chief State Attorney, Jonathan Mwaganya, together with the Land State Attorney, Chiza.
She's also Chief State Attorney.
The Chief State Attorney, much obliged, my Lord. Together with my land colleagues, I pray they introduce themselves on watching brief. Okay. My Lord, I've been informed by the process server that the intended witness to appear today in court, they couldn't be found. And the affidavit is on court record, I believe. The same position has been discussed with our client, Mr. Okello Onyum Christopher. My Lord, in the circumstances, since the remaining witnesses can't be found, we close the defense case. I pray.
To trace the two remaining witnesses, and the same was performed today, the 27th of April, 2026, to the effect that efforts to reach the two remaining witnesses as proposed by the accused person on their telephone numbers have been in vain or have been futile because the telephone numbers are unavailable. Since the first time they were expected to be reached out to get for their accused, and it is accordingly closed the proceeding. Shall proceed.
My Lord, whereas it's true we attended the court throughout, from the first witness, it is today that we have gotten the proceedings of court. So we are unable to proceed. And right now it's 11. We would ask for 3 hours to do this. We summarize and we come and make our submissions. I pray so, my Lord.
With 2 hours is sufficient. If I gave you 2, would you be able to run through your evidence and make the submission?
My Lord, the 2 hours are not enough. I pray for beyond 2 hours.
That's fine.
Hello. I've heard, and therefore I'm going to invite an interpreter to come and we will make a brief translation. Interpreter, please come. Interpreter, come and we do a brief.
Off on that day. At the Sabbath. Yes. At that particular time, they came on at noon. At noon, 22 hours. Still, the statement of anybody from the manager of this CCTV camera is working on the phone. PW14, Detective Mutaka Jimmy. He told the court that all exhibits were submitted by Inspector Seman, the I.O. My Lord Seman was not brought to court. So who was the I.O.? These were real exhibits brought to court. Seman did not come to court to identify any. So it touches their credibility and integrity to meet the standard of being paid in court. Much obliged, it is true. But my Lord, this is my submission. My Lord, the same person said that there were no fingerprints listed. At page 228, he said, I know the consequences of failure to lift the fingerprints, but I didn't do so. This offends the principle of proving a case beyond reasonable doubt. My Lord, PW16, Detective James, PW15. He said he supervised the inquiries. But he was not familiar with the whole police fight. My Lord, he quoted to this court that the accused person knew the consequences of his acts, and he told him so. When he was asked whether, as police officer, he knows the consequences or the importance of such a statement, he said yes, that is very important. When he was asked to point to us in the whole police file where this statement is, he confessed it is not there. My Lord, if at all he knew that this statement is very important and it's the backbone of this case, and all the witnesses plus police experts failed to write it on the record, if court holds otherwise, it will lead gross miscarriage of justice. I invite this court to disregard this statement as being misleading. My Lord, at page 245 of PW16, Mpamizo Agri, plus another officer, my Lord, they confirmed to this court that as this case was going on by 13 April 2026, inquiries were still going on. My Lord, this kind of evidence touches Article 28(1), the doctrine of fair hearing, and also preparing for defense.
But we never at any one time raised an issue of lack of preparation.
My Lord,
We only raise it now this time. I find it irregular and almost unprofessional.
my Lord, allow me to use Article 28(1), fair hearing, which is a non-derogable right. My Lord, as inquiries continue when court is continuing, it offends that act.
So would never at any one time raised that when we were proceeding. When they brought that and disclosed it, we never brought it to the attention of the court. So I find it irregular that you're raising it now.
My Lord, let me allow me to give this explanation. My Lord, it's not the defense to prepare the prosecution. As defense, I can look at evidence and do not cross-examine it because I know it's irregular. In my submission, I put it there.
No, you don't do that because it's not right. If you thought the disclosures were given to you and you have no adequate time, you should have informed the court and I would have given you that time.
My Lord, I consider that wisdom, but as I was cross-examining, witnesses were conceding to that fact that, and they were reading to this honorable report that I made my report on the 17th day, April 2026.
That is very true, but at the time they came to testify, the disclosure was made to you, and you never at any one time informed the court that you had limited time. To be familiar with the report, which time I would have given to you. So when you raise it now, I am again saying it is irregular.
My Lord, I pray that you allow me to quote this. At submission, any offending of the law can be brought to the attention of God. But my Lord, thank you for the overruling me.
And of course, this is of course without any offense. Okay? Yeah, because you see, if that's the reason you are there. If you have any issues with either late disclosure of some of the evidence, you should have brought it to the attention of the court, but you did not.
Much obliged, my Lord. PW 17, my Lord. Assistant Superintendent of Police, Halima Bala. My Lord, he said that the bodies were tampered with of the late by the time an examination was carried out. The scene of crime.
Mr. Kumuga,
Yes, my
this
Lord.
is a DNA analysis.
Yes, my Lord.
He did not see the bodies. He saw samples from the bodies, the swabs from the bodies, but not the bodies themselves.
Much obliged, my Lord. My Lord, let me read to you this verbatim and then you advise.
Okay.
The suspected shot shown that there was only the DNA, yet we were told he was subdued and arrested. By the time, by people, by the people, how come that the DNA was not found on his shirt? That's the question, my Lord, this honorable court should be answered.
No, I don't answer questions. I want you to read for me that and give witness statement.
Yes, this officer is identified, I think should be forwarded to the Judicial Service Commission. But there is no court seal to identify the court that participated in this. Therefore, where did these documents originate from that led to this kind of inquiry? This particular evidence was brought to the attention of court. Prosecution ignored to bring any witness to clarify this. Therefore, in the absence of the officer from court, I invite this court to hold that this does not amount to a court order. Therefore, whatever is started on falsehood, the end must be false. I pray that while coming up with this judgment, court regards this evidence. However, I will go ahead and continue analyzing whether it was relevant or not. My Lord, in cross-examination, this particular investigator was asked whether his name is on the record. He said it is not there.
On the report.
On the report. And I believe my Lord is well learned to know the consequences of failure to write your name on a report. Because he is a professional police officer. And he was asked whether his national ID has his name. He alluded, said it is true, his name is there. So he knows the consequences. My Lord, this person was asked whether the alleged police hotline 112 and 99 were called off, and whether he had any writing or voice email to show that that voice is connected the accused in court. He said he has no writing or voice. And he alluded to the fact that he has left it for court for guesswork. My Lord, on issue of Google search, he alluded to the fact that doing a search on Google does not offend any law in Uganda. He was asked whether he knows his investigating colleagues went to find out whether this person after Google went to the particular school, particular institution. He said he doesn't know. So this evidence is on court record idle. In case they wanted to rely on it, it offends the principle of proving a case beyond reasonable doubt. Meaning his search on Google never offended any result. My Lord, the concluding remarks on this kind of poor investigation is stated herein. Poor investigations are not mere administrative errors, but systematic breakdowns that cause profound harm to the victims. And erode public trust public trust in law enforcement. Poor investigations and negligent inquiries frequently result in too wrongful detaining innocent individuals. My Lord, allow me to rest my submissions here, and I leave it to court to determine as to who participated in this kind of crime. I bless you.
Thank you very, very much.
Okello, Onyum.